The starting point for understanding how the legal profession polices itself is the 2022 Annual Discipline Report published by the State Bar of California. The report leads with a specific performance metric, showing that 86% of all disciplinary cases met their processing goals. The state frames this efficiency as a direct victory for public protection. The logic provided in the report suggests that by processing files faster and decreasing the total case backlog, the bar is actively holding attorneys accountable. The math at the end of the pipeline tells a completely different story. Nationally, the weighted average for complaints that result in any form of public accountability sits between 1.8 and 2.2%. In California, the outcomes are even lower. While the bar processes files efficiently, it dismisses 99.3% of all written complaints. Regulators consistently attribute these massive dismissal rates to the public. The standard defense is that the sheer volume of complaints filed by clients are meritless, frivolous, or completely outside the bar's jurisdiction. The data maps a different mechanism. The near-zero discipline rate is the mathematical byproduct of four sequential, opaque, and unreviewable administrative filters. Moving paperwork quickly through an office clears out files. It does not mean the system is effectively regulating the legal profession. To understand how hundreds of thousands of public grievances just evaporate, we have to look at the sequential filter model of impunity. This tracks how raw intake is methodically reduced to a statistical zero. State bars operate a two-tiered system. A microscopic fraction of cases enters the visible system, where the public can see the results. The overwhelming majority die in the invisible system, protected by strict confidentiality rules. There are four distinct filters that achieve this: the denominator fallacy, intake screening, procedural ambiguity, and final investigation attrition. Each stage acts as a hard barrier, choking off the volume of complaints until only a microscopic trickle remains. By stepping through each filter, we can locate the exact points where public concern is structurally eliminated. The elimination of complaints begins at stage 0. In California, this represents roughly 165,000 initial contacts, phone inquiries, and calls that occur before a single piece of paper is officially filed. State bars calculate their official dismissal rates using stage 1, the written complaints. By excluding stage 0 from the math, they commit the denominator fallacy, erasing the largest segment of public grievance from the official record. Between an initial phone call and a successfully filed written complaint, there is an immediate attrition rate of 75 to 85%. This drop occurs at the Attorney-Client Assistance Program, or ACAP. The program acts as a gatekeeper, informally resolving disputes over the phone and closing the matter before it can ever be documented as a formal complaint against the attorney. When you recalculate California's accountability rate using the true denominator of 165,000 actual public contacts, the percentage of attorneys facing public consequence plummets to 0.06%. This math holds steady across different jurisdictions. North Carolina registers roughly 35,000 stage 0 contacts, yielding an almost identical true accountability rate of 0.05%. Filter 1 ensures that 8 out of 10 people who contact the bar about a lawyer never enter the statistics as having made a complaint. By shrinking the denominator right at the intake threshold, state bars make a sub-1% accountability rate appear statistically favorable compared to reality. The complaints that survive the phone phase reach filter 2, initial intake screening. Depending on the state, anywhere from 5 to 88% of these written complaints are dismissed outright, without ever being officially docketed. For the cases that do pass intake, we hit filter 3, the stage 2 ambiguity. States use the word docketed across the board, but the term acts as a linguistic mask hiding 3 entirely different administrative realities. In the investigation models of Florida and Illinois, passing the screening threshold and opening a file means a substantive investigation has actually begun. Maryland and Virginia use an administrative model. Docketing a complaint here is a purely clerical act. It assigns a file number, but 80% of those cases are immediately dismissed without any investigation. In these states, Bar Counsel conducts a second, substantive screening only after the case is docketed. They dismiss the vast majority of these files without ever requesting evidence or contacting the attorney for a response. North Carolina utilizes a committee model. Even when files reach the grievance committee, 89% are dismissed without an order to investigate. Reaching Stage 2 in most states is not a commitment to a factual review. It is an administrative holding pen. Complainants receive notice that their file has been opened and docketed, creating the promise of progress, only to face an immediate structural dead end. Filter 3 eliminates between 10 and 95% of the cases that actually survived the first 2 rounds of screening. Being docketed gives the appearance of a functioning regulatory system, while rarely resulting in a substantive investigation of the attorney's conduct. The final internal barrier is Filter 4, post-investigation dismissal. For the few cases that are assigned to an investigator and gather evidence, 85 to 99% are still dismissed. This means the most significant block of attrition occurs at Stage 3, well after a complaint has been validated by intake staff as non-frivolous and worthy of state resources. All of this brings us to column P, the formal filing of charges. This line serves as the absolute boundary of public visibility. Every filter discussed so far, filters 1, 2, and 3, along with the Stage 3 investigation itself, exists entirely in the gray zone. The details remain permanently hidden from the public, media, and judicial scrutiny. The consequence of this secrecy is total. An attorney could have a history of 50 dismissed Stage 3 investigations involving serious allegations, and any client looking them up will see a completely clean record. Only when a case crosses the column P threshold does it finally become a matter of public record, initiating formal hearings and status letters. The math of the pipeline compounds on itself. The survivors of Filter 1 are multiplied by the dismissals in Filter 2, Filter 3, and Filter 4. This sequential multiplication is exactly what produces a final 0.5% outcome rate. The primary output of the attorney discipline system is not discipline, it is confidentiality. We finally reach Stage 5, representing the fractions of a percent of cases that survive the pipeline and receive a final order of public discipline. Even here, the language obscures the reality. Public discipline is an umbrella term that conflates strict practice restrictions with simple verbal warnings, splitting into 6 distinct pathways. In official data, a state issuing 90% reprimands looks identical to a state issuing 90% disbarments. The data logs them both as successful public discipline, but the actual risk to the public is drastically different. If a family court attorney receives a public reprimand in Stage 5, they are formally censured. The next morning, that attorney is back in court practicing family law without a single restriction on their license. Furthermore, consent discipline relies on negotiated outcomes between the bar and the attorney. These settlements clear the docket, but often fail to reflect the severity of the original misconduct. The accountability delivered at the very end of the funnel is frequently as diluted as the process that led to it. The pipeline begins with a 100% baseline of public concern. It is filtered through 4 sequential opaque blocks until it yields a true accountability rate of 0.06. The attorney discipline system operates exactly as it is structured to operate. It functions as a series of administrative bottlenecks designed to preserve the status quo of the legal profession. It is a complex machine that expends massive energy and resources on internal processes, ensuring that output is minimal. Until the invisible stages of this pipeline are made public and reviewable, a 99.5% attrition rate is not evidence of frivolous complaints. It is evidence of regulatory capture.